Okay, good morning everyone if you are here in California, and welcome to our guests from Israel and from the East Coast around the US. My name is Sharon Vanek. I'm the Executive Director of the California Israel Chamber of Commerce, and I am very happy to have our guest today as we are going to get into a discussion about going back to the office. We are all waiting for the news from Governor Newsom and from the local authorities around here to know when we can actually go back to normal. And the biggest question is, what is normal? So before we start, I'd like to mention that the California Israel Chamber of Commerce is a nonprofit based here in San Francisco with an office in Israel. And our mission is to support Israeli and American companies to meet and to be engaged in business conversations. I'm very happy to have this morning our friends from Squire Patton Boggs. We have Michael Kelly and we have Sam Mudrick from Squire Patton Boggs, who are going to help us to understand what are the legal implications of going back to the office. I also want to mention that this session is being recorded and it will be later on available on our YouTube channel. I also want to mention that everything that is being said this morning is not of a legal advice. If anybody needs a legal advice later on, you are welcome to approach our guest today and seek a particular individual advice. You have the contact information later on. So before we start, I want to make sure that everybody can see my screen, and I'm going to introduce our guest. So hold on, I have a technical problem. My slides do not move. Just 1 second. What happened? If you can you see my screen?
Yes, we can see the slides.
Okay, so I'm trying to figure out how to move to the next slides that from some reason doesn't work at this point. Michael, can you welcome and can you introduce yourself while I'm trying to figure it out?
Sure, not a problem.
Here it is.
Very good. Hi, everyone. Another picture of me, that one a little bit more formal. I am a partner in the San Francisco and Palo Alto offices of Squire Patton Boggs and have been specializing for the last 20 years here in California, specifically on employer compliance with California's many labor and employment laws. Obviously, that's a landscape that has shifted considerably since about the middle of March, and we've been working closely with regulators as well as with clients in understanding what those rules need to be going forward to keep everybody safe and to minimize your legal risk. Thank
you. Sam, can you introduce yourself with a few words?
Yeah, it's a pleasure to meet you all. I shaved, first of all. I'm a partner in our DC office specializing in corporate immigration. So I've been practicing for about 15 years in the immigration field, here with Squire Patton Boggs for that whole time. The practice is generally representing multinational companies, helping them transfer people, make sure their compliance programs are in order with I-9s and other types of immigration-related compliance. Also work with investors trying to come to the United States or trying to start companies in the United States, making sure that they have the corporate and the immigration synced together. And I have a nice, strong pro bono practice as well, with some family-based and lower-income individuals, helping them navigate the difficult immigration field that we have here in the United States.
Fantastic. Thank you both for being here this morning. First, I assume that our audience want to know if there are any standards that employers need to obey by, when talking about going back to the office.
Absolutely. And Sam, let me take this first. It's important to remember when you're dealing with employment issues in the United States that we have multiple levels of regulation. Unlike many other countries where you have one set of rules that everybody has to comply with, here there's federal, state, and increasingly with COVID-19, local regulation. At the top of the food chain is the Occupational Safety and Health Administration, called OSHA. That is a federal agency, and OSHA has lots of regulations that deal with very specific workplace hazards, drill presses, welding equipment, and things like that, none of which most of our clients in the tech space really have to deal with on a day-to-day basis with software and basic office work going on. What has come to the fore with the COVID-19 pandemic is the general duty clause, which is simply a catch-all provision in the law that requires that every place of employment be free of recognized hazards that are causing or are likely to cause death or serious physical injury. In particular with COVID-19, we see issues around personal protective equipment, the ubiquitously discussed PPE coming up regularly, as well as sanitation and social distancing issues, all arising at the federal level under the general duty clause. Then we have at the state level, excuse me, a California analog to OSHA, unimaginatively, excuse me, called Cal OSHA. They have other rules, and they have specifically dictated that COVID-19 is a workplace hazard. Under Cal OSHA, every workplace, even something as seemingly safe and hazard-free as a law firm, needs to have an injury and illness prevention program. That's a written document that outlines how you will deal with known hazards. Now that COVID-19 has been identified specifically as a known hazard, the state last week issued guidelines for employers. Every employer should update their IIPP to make sure that they address COVID-19 issues specifically. For a lot of our clients that have low hazard workplaces like offices, the notion that they actually had to have a written IIPP came as a little bit of a surprise to them. So this is, if this requirement is catching you by surprise, you're in good company, but there are lots of resources online, as well as resources from law firms like ours that can help you jumpstart and get where you need to be with respect to a COVID-specific injury and illness prevention program.
Thank you. So you mentioned the fact that a lot of your clients are in the office, and most of our audience here with the CICC are what is called white-collar, industry employees. And when we talk about going back to the office, and we see that most of the people that actually go back to work at the beginning are those in the retail stores and so on. And for employees and employers, they not necessarily see eye in eye about what is risk, right? So they might think differently about the level of risk that they take while going back to the office. Are there any specific categories or definitions maybe to what is risk taken and how risky is going back to an office versus to, let's say, Safeway or any other restaurant or retail store?
Yeah, we work closely with the National Institute of Occupational Safety and Health, called NIOSH, which is a federal agency, and NIOSH loves pyramids. And so the first pyramid we're going to show you is NIOSH's COVID-19 4-tier risk levels. And you can look at this and line yourself up with exactly where you think your employees are going to fit. And one thing that's important to remember is not every employee is going to be in the same risk category. So you may have a low risk workplace, but have people who are working in a warehouse, or maybe they're in a reception position and they have more contact with the general public. And so a lot of your folks may be low risk, but some of them may be medium. And as you evaluate what measures you need to take to protect them, you need to recognize that it's not a one-size-fits-all for the company. It's really on a position-by-position basis. Frequent contact with the general public or with international travelers puts people in medium risk. High risk is more healthcare delivery, medical transport, mortuaries, which probably we're not talking to anybody from the mortuary business. And then at the highest risk is more healthcare, and that would be kind of high risk might be your dentist office and your general practitioner. Very high risk is your emergency rooms and ICUs, laboratories that are actually working with COVID-19, that sort of thing. So that's how NIOSH approaches the risks. The next question is, what do they do with the risks? And if you want to flip to the next slide for us.
Sure.
One of the things that's interesting about this is for a lot of employers, it appears to be upside down. And I say that because if you listen to the media and you talk to your friends and neighbors about what's going on, PPE is the topic that people tend to be focused most on. But the reality is NIOSH's view is PPE should be the protection of last resort. And in particular with COVID-19, because we don't really have a mode to eliminate or substitute for it yet, employers are expected to implement engineering controls, then administrative controls, and finally, as a last resort, PPE. And that requires more thoughtfulness, and in some instances will involve some investment by companies in changing the physical nature of the workspace, as well as changing how people work once they come back, and regulating who exactly does come back.
Okay. But with all these precautions, there is always a chance that someone at the office is going to get sick. We don't know where they contracted COVID-19, but what do we do if we know that one of our employers is getting sick? And at the same time, as many of us are also employees in the company, what should we do? Who is responsible for that?
So in the first instance, the employer is responsible. Actively encourage and direct sick employees to stay home. I actually have a client that fired somebody last week because he came to work on Monday and Tuesday, and on Tuesday happened to mention to one of his colleagues that he had been with his brother on Sunday and his brother had tested positive for COVID-19. You absolutely want to make sure that you are clearly communicating rules about employees staying home if they feel sick and employees staying home if they have been exposed to COVID-19 until an appropriate waiting period has passed. Send employees home. Is really our vibe where somebody has COVID symptoms.
Okay. I also want to take this opportunity to advise our attendees, if they have questions, you can use the Q&A box at the bottom of your screen and ask questions. I actually received a question on my phone, and I want to ask you, Michael, to address it. So what happens if there is a company that works in a co-working, operates out of a co-working space? You know, it's not our own office that we can control. What do we do if we are in a WeWork type of a facility? This is one question. And then the second question is, what if we are in an office building and we can assume responsibility, I guess, from the door to our office? What happens from, let's say, the parking lot until our employees actually get through the door?
Yeah, those are both really good questions. And let me start with the second one first.
Sure.
It's important for employers to think about every moment of an employee's workday from when they arrive in the parking lot to when they leave at the end of the day. For example, you probably want to make sure that employees are putting a mask on when they get out of their car so that they're not running into each other in the parking lot and potentially exposing each other. Most employers will be requiring employees to take their temperature on a daily basis. A lot of companies are doing that themselves. If you're in a shared building, you might work out with the landlord whether the landlord, or in a WeWork space, whether the WeWork host will be administering that at their front door, as opposed to once somebody has worked their way all the way through to your space. From a technical labor law compliance perspective, hourly employees, those that you pay based on the time they work, they need to be paid for the time they spend waiting to have their temperature taken. That can be a problem because most employers will have the time clock on the other side of the door, and so the employee will be waiting before they can clock in. And so you'll need to make sure you allow for that time and allocate some extra time onto their timesheets on a daily basis. Because one thing I can guarantee you, when this is over, plaintiffs' lawyers are going to be rummaging around for lots of technical legal issues to file class actions about, because they have to make payments on their office space and pay their staff just like all of you do. Unfortunately, the way they get the money to do that is by taking it from you in lawsuits. So you do need to think about those issues. Sharon raises good questions in shared spaces. You need to talk to your landlord now about how basic functions like elevators are going to work. Is the landlord going to limit the number of people on an elevator at a time to 2 or 3 to maintain social distancing? What are you going to tell your employees about getting to work if you realize that it's going to take them 10 minutes to come up in the elevator because they're going to have to wait their turn? An administrative control you could adopt is staggering your employee start times so that rather than having everybody arrive at the office at 9, they arrive in small groups staggered by 10 minutes. Again, reducing the amount of contact they have and reducing the amount of time people your space. Again, you need to talk to
Michael, you're breaking up. I don't know if it's only on my end. Sam, can you hear Michael well?
No, he froze on mine too.
Okay, so it's probably something on Michael's end. So I'm going to jump forward until we get Michael back online with us. And I'm going to actually try and move to the next topic, which is more relevant to Sam, what you are dealing with. I see that we lost Michael for now. So Sam, your expertise are more on foreign, let's say foreign employees that we have, and a lot of our companies have, if it's Israelis or you know, other nationalities, employees either planning to come to the US or traveling to meet their clients. What's your take on that? Can you share some insights?
Sure. So maybe to start, it would be good to address some of the changes that might be happening to your US workforce that are foreign nationals that are on visas. So we're talking there, if you want to go back to the furlough one, it would probably be a good one.
Oh, sorry.
13. We can address that quick. When Michael gets back, I think he can come back in. Yeah, the one right after.
Okay, this one. Sure.
You know, then we can get a jump on that issue for when Michael comes back.
Of course.
But essentially, Michael's going to address a little bit more the general issue with furloughs and temporary layoffs or determinations. But when it comes to visa holders, you've got to be careful because some visa categories are really strict on what you're allowed to do to change the work of an employee that's on that type of visa. So on the next page, I distinguish between the two types. The first category is people who really have some strict requirements when it comes to a furlough. And that's on slide 30. Yeah, there you go. So we're talking about the very common visa is called an H-1B. Others are an E-3 and an H-1B1. Essentially, those are controlled by something called a labor condition application. And the LCA establishes where the person can work and for how much the person can work. So you're not allowed to drop below the pay that you're required to pay, and you're not allowed to change their work site with a very few exceptions. And so one of the issues, for example, that a lot of people are addressing, and I see Michael's back, so I'll actually pause, but before I hand it back over to him, I know he's going to talk a bit about telecommuting and as part of the mitigation with COVID. And so just to get a jump on that one, when it comes to visa holders, there are ways that you can telecommute for your visa holder workforce, but you have to sometimes make additional filings. So if someone is in one of these these visa categories, like an H-1B, for example, and you decide they're going to need them to work from home, you actually have to file a new filing at their home office and post it in their home office. The LCA has to be posted at the home office for 10 calendar days. Technically, it's supposed to be before they start to work from home, but you have a 30-day grace period now. So hopefully if you all have visa holders working from home, you've already done that. If not, it's always just a good idea to go ahead, comply with it, get that posting done, and document it in their immigration file in your HR files as well. But I'm gonna tag back over to Michael and see if his mic's working.
Okay. Mike, can you hear us? Michael?
Yes. Can you hear me all right?
Yes, now we can hear you. So I'm going to jump back to the slides where we stopped. I'm sorry that the screen is jumping like this. We were here and we talked about co-working spaces and employers' liability in that situation.
Yeah, so the bottom line is the fact that you're in a co-working space makes it more complicated for you because you need to coordinate with the other occupants of the space and make sure you work out with WeWorks or whoever is the hosting company what the communication protocol will be to make sure that all of you are able to meet your obligation to do contact tracing and safeguard your employees.
Right. There is another question that we received a few days ago when we actually spoke about it. It's not about the prevention of COVID-19 or the potential exposure to COVID-19, but it's about travel to the office. And there are different counties here around California. Some of them open, first. Some of them are not even talking. We have no future date when that will be open. What do we do if our office is in an open zone, but we live in an area that is not? And then the employer tells us you have to come to the office because we are open. What do we do then?
So an employer should not be telling an employee that they have to come to work if the employee is subject to a legal restriction that prevents them from coming to work. The most classic example of this in the earliest days involved employees who lived in the Lake Tahoe area and worked in Reno, Nevada in casinos. California obviously did not consider casinos essential businesses, and they had ordered people to only leave their homes to go to work at an essential business. An employer in Nevada should not be ordering their California employees to break California law to go to work. Similarly, if, for example, the employer is in Napa and the employee is in San Francisco County, and the job is not an essential job in the eyes of San Francisco, and so San Francisco is ordering that person to remain in their home, it would be contrary to public policy for that employer in Napa to be firing employees for continuing to comply with the order.
Yes.
If this goes on for months, ultimately the employer in Napa is going to have staffing issues, and they're going to have to make some harder decisions about whether they can continue to employ somebody who is unable to report to their work site. But right now, all of the counties in the Bay Area and generally the state of California seem to be making progress toward reopening. And so I would counsel employers to be patient in those circumstances and not dictate that employees cross lines if it's really clear that they're not required to. The other thing I would suggest, because there is still some sensitivity about people crossing county lines, is if you have an essential business or you have a business that is authorized to reopen and you have employees who you think might run into trouble because they're crossing county lines, you can give them letters that they can put on their dashboard to indicate that the reason they're driving is because they're supporting an essential business or a business that's subject to reopening. And my impression is that law enforcement is going to be pretty accommodating to that, unless you're parking your car, along the coast or in some tourist area where the communities are still very sensitive to out-of-towners coming in and potentially contaminating their environment.
Thank you, Michael. So let's go back to these slides that you prepared. I know you prepared a few slides about infection prevention and the steps that employers need to take, because I think this is a burning question. Just because of liability, people want to make sure that they do everything they have to apply by the law, just to make sure that they won't be accounted responsible if somebody is getting sick. So you want to start with this slide?
Yeah, actually, why don't we go on to the next one? Because I think we've talked about actively encouraging sick people to go home.
Okay.
A question that we get a lot is, back one.
Back one.
There we go. A question that we get a lot is, if somebody is out with some kind of symptom, how long do they need to stay away? Because there's still delays and sometimes people aren't getting COVID-19 tests.
Mm-hmm.
The latest guidance as of last week that we've received from the state of California would have employers where an employee has some symptoms like a fever or a severe cough, they need to stay out of the office until at least 3 full days pass where they have no fever or respiratory symptoms, and it's at least 10 days since the symptoms first appeared. Also, as we talked about previously, employers should be taking employee temperatures, and most of all, continuing to encourage employees to telework from home as much as possible. One thing that everybody should be aware of, until July 6th, California is going to have a presumption under the workers' compensation system that any employee who reports to work and who tests positive for COVID-19 will be presumed to have gotten it at work. And so that means that if you have an employee who shows up at work on July 3rd, on July 4th, they go to an Independence Day picnic, ignore social distancing, nobody wears a mask, and a few days later they test positive, that will still be presumed to be a workers' comp claim. The governor, I think, did that intentionally because he wanted to make sure that employers had some skin in the game, that they were liable for potential exposures. It means that you're also liable for many out-of-work exposures. Switching gears to engineering, mentioned physical barriers, partitions. There's a picture on the slide of a pretty classic startup workspace. If you have a workspace that looks like that, you should be considering putting plexiglass between the workstations. You should also be looking at how many empty stations you can have between one person and another. It's possible that the only way you'll achieve that is by starting to work in shifts. You may, for the time being, have some employees who work Monday, Wednesday, and Friday and work from home 2 days, and vice versa. You may have an afternoon and an evening or half-day shifts. Anything, you really need to do everything that you can to maximize 6 foot minimum spacing between employees. I know in our offices, one of the things that we're doing is marking the floors just like grocery stores to remind people that they should only walk one direction in the hallways to avoid passing each other. One of the hard things to accomplish right now is getting the cleaning supplies that you need. It is clear from the state guidelines that you will need to have mandatory sanitary practices, including detergent wipes and things like that, used regularly for common areas and also available for employees to use in their personal space. And sourcing that stuff is hard right now. Just walk through a Costco and you'll see the nature of the problem. Having those is sort of table stakes. It is a minimum ante that employers are going to have to meet if they're going to reopen and have employees regularly in their workplace, let alone customers. And, you know, I had a client a few weeks ago who had an individual come into their work site, asked about wearing masks, and was told that the company did not require masks. It was a miscommunication, but that person walked right out, called the Fremont police, and within 15 minutes, 2 squad cars with 4 cops had arrived. They thought they were going in to shut the place down. Thankfully, everybody they saw had masks on. But these will be enforced by law enforcement who can shut you down, as well as you can have fines, you can have OSHA penalties, and worst of all, potentially, if an employee gets sick, you may be found liable outside of the workers' compensation system for an intentional tort. And there, the monetary damages and punitive damages can be particularly expensive for you.
I have a question about the last sentence you mentioned, Michael, about being sued. One of the things that we discussed prior to this conversation today is the difference between full-time employees and part-time employees and how that affect our health insurance and liabilities. Can you address this, please?
Yeah, it's a quirk of American law that, unlike many countries that have national health systems, in the United States, the basic way that individuals get health insurance is usually through an employer-paid group health insurance plan. If you have a lot of sick employees, your premiums at renewal time go up. This is true whether you have several employees that have heart attacks or you have bad experience with some employees getting into auto accidents, but bad experience makes for bad premiums. The same is true with COVID-19. If you have employees who are getting sick with COVID-19, it will adversely affect your insurance experience. And next year, when you go to renew, your health insurance premiums will be greater. The presumption that Governor Newsom created with workers' compensation has the same effect in that it means that lots more employee claims will be compensable under your workers' compensation program. To some extent, that is simply trading liability from your general group health insurance policy to your workers' comp policy. However, if you have a lot of part-time employees who are not members of your group health plan, those individuals, those claims will just sit on your workers' comp. So the governor's presumption in place through July 6th increases the risk to you specifically on a long-term economic basis with respect to your part-time employees. To the extent you have choices to make about calling people back before July 6th, erring on the side of leaving part-timers home longer and bringing in full-time employees would help offset the risk created by the presumption.
Thank you.
The other way to do that, sorry, Sharon, go ahead.
No, I wanted to ask you the next question, but I let you finish your line of thought.
Actually, I think my line of thought is going to dovetail with your next question. So why don't you go ahead and ask it and then we'll see.
Okay. Okay, so unfortunately, as we all know, many employers cannot continue to operate in full capacity. There are so many reasons why they cannot operate in full capacity, and we are not going to get into those reasons. But we are more interested to learn about furloughs, layoffs, and all of this, because unfortunately, there is an Excel sheet that runs around California, and we see the number of companies that have to, unfortunately, part from their employees. So can you address the situations and what's going on in that regard?
Yeah, so you're absolutely right. Unfortunately for the state of the economy, there have been catastrophic job losses. And I think many employers that wanted to minimize job losses as much as they possibly could are now starting to confront the fact that the market for their products have changed, and the long-term prospect of employing a lot of people has changed as well. When we talk about furloughs, that is essentially a temporary layoff. That is the circumstance where you're telling an employee, we don't have work for you now. We're not going to have work for you in the coming weeks. We think we're going to have work for you in months. And so we'd prefer not to call this an outright termination, but we need to let you go for now, and we'll call you back as soon as we're ready. In California, the difference between doing that and firing an employee is pretty small. And I say that because, first, that individual who has been furloughed or temporarily laid off, they're synonyms, is eligible for unemployment benefits, and they should file for unemployment immediately. And second, if you temporarily lay somebody off and you don't give them a definite return date in the same pay period, you have to issue them with a final paycheck, which means you have to pay out any accrued vacation benefits or paid time off that they have. So be sure you're ready with a final paycheck if you're having furlough conversations with people. Yeah. Those who expect that these people aren't coming back, they need to look closely at what are called WARN Acts. And those are laws that trigger notice requirements, and the failure to provide that notice can result in you owing the employees up to an additional 60 days of pay. So those are laws you really want to pay close attention to.
Yes. I know many of our viewers are HR managers, in different levels. I just want to make sure before we move to the next topic of visa holders and foreign employees, also addressing this point, if the business is registered in California, but we have employees in other places, and vice versa, if the headquarter or the business is registered outside of California, but we have some employees in California, what rule takes over?
So employment law in the United States generally operates based on where the employee works. So you'll need to comply with California law for all of your California-based employees, and the law of whatever other state the other employees where they live. And especially with startups who frequently have people teleworking from places all over the country, that can become cumbersome as well. But the applicable law is the law where the employee is working for you.
Okay, great. Thank you. So, Sam, we're going back to you, I guess, with a topic that we jumped ahead earlier. Talking about startups and Israeli businesses, but not necessarily, obviously, for Israeli businesses, but any business, and a lot of them around California have foreign employees. Either employees that are on the verge of relocating to the area from overseas, that are through the visa process. I know a lot of consulates are closed. Let's dig into this subject.
Sure thing. Let me piggyback onto Michael's most recent topic about furloughs first. So we have the slide up that talks about what I'd started talking about before, sort of the distinction between the different categories. Actually, you can go back to the other one now. So essentially you're broken into two categories. As you have most employers will just do an across the board furlough or hours reduction or wage reduction or layoffs. And so a lot of times visa holders get swept up into this, into these furloughs because they're seen just as normal employees. But you really need to make sure you consult with your immigration attorney before you take any action against a visa holder, because it could jeopardize their status and could make them removable. The first category is this group, the protected one. You see under strict requirements, we're talking about visa holders under H-1B, E3, and H-1B1 visas. Those ones are controlled by a document called a labor condition application, an LCA. And that LCA says the wage that you're required to pay them, which is the higher of the government prevailing wage or what you pay other US workers in the same job. And it also says where they can work. And so it has the actual address of the work site, and you can list multiple work sites on the LCA. But if you want to move them to a work site, as what we had talked about before, sometimes you need to post that LCA at the new work site if it's a home work site. And that home work site, in order to avoid filing an amendment, has to be within about 100 miles of the normal work site, which most people aren't commuting more than 100 miles. But if you have questions, make sure you talk to your attorney about that one as well. If there are wage changes, so obviously a furlough would be a stop in wage, you really are dropping the person out of status if you do that in these categories. Even if it's a wage reduction for H-1Bs, E3s, and H-1B1s, that could make them fall out of status because you're not paying what you legally committed to pay on the LCA. And so you have to be really careful. And sometimes I have clients who have decided, you know what, we're going to furlough everybody, but we're going to take special precautions not to go below that wage for other people who are on these visas, because they don't want to have to go back through the process of having to redo the visa later or of filing a visa amendment now. There is a little more flexibility for this other category, which is most other visas. Really, the L1 visa is used a lot. Israel, as of last year, qualifies for the E2 visa for treaty investors and traders, TN for Canadians and Mexicans. So the big question on this one is whether the change in the employment is a material change. Obviously, a furlough, it's going to be a material change. And so that would essentially mean that the person is no longer fulfilling the requirements of their visa. But if it's a minimal, say a 10% pay cut or a 20% pay cut, you might be able to get away with that. If it's a minimal hours cut, you might be able to get away with that. The jump from full-time to part-time could mean that those people are falling out of status. There is a 60-day grace period for those types of visas. And essentially what it would mean is if you had to furlough someone and it was for under 60 days, some employers are deciding that they say, okay, you know what? We're going to bring them back full-time, normal, same as before within the 60 days. And they're going ahead and using that 60-day grace period to say that they're back in status. It's a little risky. And if you decide to do it that way, make sure you talk to your attorney first and understand that that grace period can only be used once. So if they end up being terminated, just a solid final termination, they would not have that grace period anymore and they'd be immediately out of status if that happened in the future. Another thing to think about, especially with a lot of California companies, they use a lot of student employees. After they've graduated from US university, they get 12 months to 3 years, depending on their degree, where they can work on what's called optional practical training, OPT. And those employees, if they are furloughed, they only have a certain number of days that they can be unemployed. It's 90 days for a standard OPT, and if you have a STEM degree and you're on your STEM extension of OPT, it's an additional 60 days. So whenever you're dealing with a student, make sure that you as the employer are very open in your communications with your students and that you're making sure the student is in constant contact with the International Student Office at their university here in the US, because if they fall out of status, the consequences can be pretty severe and they might have to leave the country. Otherwise, you know, you just want to make sure you talk to immigration attorneys before you take action against a visa holder.
Thank you. So we talked about furloughs and other measurements that not measurements, other means that we might take with our employees. Now let's talk about the employees from the employees' perspective. What are they eligible to receive from the employer? Can they take time off? And you know, if they feel anxiety about the situation, can they say, I can't come to the office for X days? Can they go to the doctor and get a note that will allow them to stay home? And what can they do?
So At the federal level, for employers that have less than 500 employees, there are paid leaves under the Families First Coronavirus Relief Act. And those paid leaves typically fall into two categories. The first is related to people who are diagnosed with COVID-19 or have a doctor's note that they are a high-risk person and therefore they need to stay at home. And finally, those who have not yet been diagnosed but are waiting for a diagnosis. And those individuals have 80 hours of emergency paid sick leave under that law. The other category is paid time off for individuals who are staying home because they have children and their child care provider or school is closed because of COVID-19. Those leave for that purpose is paid out at 2/3 of somebody's regular rate of pay. Actually, their weighted average regular rate of pay, which is a little bit complicated. If you have an employee who you think falls into this category, you should probably talk to a lawyer briefly to have them walk you through that calculation because it's not intuitive. But individuals in those categories have access to paid time off. The other scenario you described, which is a common one, is somebody who is simply very nervous about working in the post-pandemic or in the current pandemic pre-vaccine environment. You could put me into that category. I'm really not excited about the idea of getting on a BART train and commuting back to San Francisco again. And if I had a job where the firm was telling me that I needed to be in the office, there is not a specific leave of absence available to me that I can just simply say, well, I'm too nervous to come to work. And so people in that circumstance really do need to be worked with by management to try to convince them to come to work, but ultimately that is an obligation. On the slide, there's a notation here about municipal ordinances. One thing that has happened, Congress passed the FFCRA for employers with less than 500 employees. A number of cities in California have adopted local ordinances that address employers with more than 500 employees, with the notion being that they wanted to create some paid leave benefits for individuals from larger companies. There is a tax credit you get for what you spend on the FFCRA leaves, but not the municipal leaves. And each city has adopted it a little bit differently, and each city counts the number of employees a little bit differently. And so again, if you're operating, whatever city you're operating in, you need to check for municipal laws as well as the basic federal and state laws.
Yeah. So I received a question regarding the possibility that sometime in September, and it doesn't matter if it's here in California or in other places around the world, schools will not reopen in the way we know it, and there will be all kind of capsules and multi-days and small groups and so on. Do you think that the regulator will have to address this situation where kids are just going to school, twice a week, and then the rest of the week they are basically at home? So that will change the way employees and employers have to work their schedule and compensations and taking time off and so on.
Yeah, that's a great question. And I think it is a given that schools are going to look different and it's going to impact employee availability. The Families First Coronavirus Relief Act expires December 31st. So the 10 weeks of paid emergency family leave available under that law for people staying home due to childcare issues, that will be available at least for the first semester of the upcoming school year. Frankly, I'm pessimistic about a national solution because Congress is becoming highly partisan on issues again. If it's what happens for January of 2021. Between now and then, I think every employer needs to assume that nothing is going to happen, and what will happen after that will be dictated by the results of the national election. At the state level, it's a hard question. So far, California has not shown an appetite to weigh into this, but they haven't had to because the federal law is still in effect. If the feds haven't done anything and this continues to be an issue, or it seems to be unworkable, I would not be surprised to see the state step in. One thing that employers should note is the emergency paid family leave under the FFCRA for childcare issues related to school closures can be used intermittently. And so an employee could, for example, work mornings and then use the paid leave in the afternoons. But intermittent usage is at the mutual discretion of the employer and the employee. So if the employee proposes something that just isn't workable for the employer can say, no, we're not going to grant this intermittently. You'll just have to use all of it at once. That has the benefit to the employer sometimes of letting you put a person in place for 10 straight weeks rather than try to have to deal with somebody who's there in the morning and gone in the afternoon if that's not workable. But at least right now, there's a fair amount of flexibility for employers. It will be there till December 31st. What school will look like beyond that? Good question. And whether the feds are going to do anything, given that they've taken the lead on this, again, I think a lot is going to depend on what happens in the presidential election.
Yeah, great, thank you. Another question that relates also to the employer-employee relationship and flexibility. A lot of companies rely on the fact that their employees need to travel. And we all heard President Trump proclamation that restrict travel. And although airlines are saying that sometime in the next few weeks they will resume flights and the skies will be open again in a certain pace, that also influenced businesses. And we spoke about feeling reluctant to take the bus or the train back to the city. What happens if we need to, our employers tell us you have to take a flight and go to X? What's the situation with that? Wait,
well,
I know we have a slide.
Yeah, I was going to say, in terms of obligating travel, the first question is, will that travel even be possible, and what rules and what impact is that going to have? And Sam's neighbor, Donald Trump there, because he lives a lot closer to him in DC than I do, is driving a lot of this train. So I'll let Sam talk about some of the travel bans and its impact on global mobility.
Sam.
Yeah. One of the things I always have to tell my clients when I'm on a conference call is my office is actually on Pennsylvania Avenue and in the flight path of Marine One, the president's helicopter. So occasionally I'll have to pause. So if you do hear any loud rumblings, that's what it is. Yeah, so we're basically, when it comes to international travel here, because that's what I talk about as border crossings, we sort of have an overlapping of restrictions. The first one is a restriction which you can see on the slide that's up right now. The president on April 22nd put into effect a proclamation to what he called pause some immigrant travel. He ended up only restricting it to people coming on what are called immigrant visas, so those coming to permanently relocate. And so he put a pause on most of those types of visas for 60 days. That's probably not most of the people you're dealing with here and the employees or the people, the visitors coming in from other countries, but that's one you have to think about. The other types of travel restriction is there's a multi-country, through several proclamations, there's a multi-country travel ban where basically anyone who's been in the list of countries for 14 days, in the last 14 days, can't come to the United States, with some minor exceptions. Generally speaking, the exceptions are for people like US citizens, people who are coming to do work for COVID, green card holders, that kind of thing. But if someone is on a visa, let's say, or let's say you just have a potential investor for your company coming from Israel, that person would have to make sure that they haven't been in one of those restricted countries. And right now, those countries are China, Iran, any European Schengen area countries, the UK and Ireland, and as of yesterday, Brazil, which has now become the second highest country in the world with COVID cases. And so essentially, if you have people in those countries, it can be virtually impossible for them to come directly to the United States from that country. Some people will actually go to another non-restricted country for over 2 weeks and then try to come in. And if you have a visa, or if you're a citizen of one of the visa exempt, it's called the Visa Waiver Program, or ESTA, you can do that. But there are restrictions in other countries too. So another thing you have to worry about, not only the ones that the president's made recently, but also whether the country you're going to or in have their own restrictions on you trying to enter that country. And then finally, there is a restriction right now on the Mexican and the Canadian border with the United States for non-essential land and water travel to enter. It doesn't affect flights, but essentially you can't cross into and out of Canada and Mexico from the United States as a tourist or other non-essential activities. The good news is if you're an employee, they deem that is essential. So let's say one of your California employers has an employee who lives in Canada, they're here on a TN visa, and they went home when this all happened, they're teleworking, but then you want to bring them back, they shouldn't have any problems. One of the things I'd say is whenever you're facing any of these issues with the travel, make sure that you talk to your airlines if you're trying to book first. They are really up to date with what restrictions there are. And if you're going to try and enter, and you're not sure about the type of visa you have or whether you can enter on the Canadian border, that kind of thing, is to reach out to the Customs and Border Protection Office. It's called Deferred Inspection Unit at the airport where you'll be doing pre-inspection, or you're actually entering the United States, and see what they have to say about your situation. But as you can see on this slide, there's some other sort of bigger issues you've got to think about. And one of the big ones is I-9 compliance. In sort of a extraordinary move, the government actually provided a little bit of leeway when it comes to I-9. Usually they're very uptight, and you all know what the I-9 is the form that every employee has to fill out starting on their first day of work, and then they have to present related documents within their 3 days of starting work to prove that they're work authorized and to prove their identity. There are a couple exceptions that they've created during this crisis. The first is that they're allowing temporary remote inspection for employers who don't have work site employees right now. So if you've made your workforce work from home, they're letting you, for new hires, now inspect using, you could use Zoom, you could use photocopy and email, and you're allowed to look at those documents that way temporarily. The only caveat with that one is it can't be if you have a normal workforce. So if you just have someone who doesn't want to come into the office, but you have normal inspection, that doesn't apply to you. And you always have the option to use an agent. You as an employer can choose anyone you want to inspect in person. And a lot of my clients who have remote workforces or spread out across the country, say they're salespeople in a state where their headquarters isn't located, they'll authorize a notary public, for example. But there are strict rules when it comes to that. And California actually has some special rules when it comes to notary publics because of some of the notary fraud that's happened when it comes to some of the Latino populations in California. So make sure that you're complying with that if you do select an agent, and that the person has the proper qualifications if they are a notary, because they actually have to be registered in California to be able to do that. Also, there have been some automatic extensions with I-9. Some of the personal documents that were set to expire after March 1st will be accepted still for I-9 purposes temporarily. So if you have a driver's license, it was set to expire March 10th, but you just can't get into the DMV to get a new one because they're not being issued. The I-9, you can accept that temporarily. You just have to, within 90 days of the crisis being lifted and the person coming to the office, they have to be able to present the real document. Along the same one, certain documents have been automatically extended by state law. So if California has said this license that would have expired this day is automatically extended, then that can be valid just as a permanent document to prove the identity for the I-9 as well. You just have to bring documentation of that automatic extension. And we recommend you print that out and put it in the person's I-9 file as well. The key really though with I-9s is just make sure you document it. With these strange exceptions, there's some special annotations. You have to put COVID-19 extension, little notations on the I-9. The government has a really good employer guidebook, a handbook that they have at uscis.gov that you can follow. Always reach out to your immigration attorney or your employment attorney if you have questions, and just make good memos to file, put documents, staple them to the I-9. If you have any questions, just make sure you over document it. Otherwise, a couple of the other agencies have provided some flexibility. USCIS, the agency that adjudicates most visa work changes, visa classification changes, not the actual visas in your passport, but from within the United States, the ability to work. They are providing extensions on some filings, like requests for additional evidence when they want more information, or if they say they're going to deny it and they want a response from you, they'll give you a little extra time nowadays. Some of the filing forms now in filing petitions allow you to use a scan of an ink signature for an official submission, whereas before they had to be actual ink. So, you know, there's some things they're providing some flexibility, which is kind of nice to see. When it comes to maintenance of status, you have some issues. This last point on this one, you've got to watch out for. A lot of people on visas are on certain visas that they like to leave the country to get the new visa and come right back in. So whether that's a TN, which you do at the border, or an E2 that you would do at the embassy abroad. So you've got to make sure that if you're in one of these types of visas, that you are planning ahead and you're filing the petition with USCIS in the United States, because that can sometimes take several months in order to do that in advance. Otherwise, you know, we see up on the screen now that there's a lot of closures. If you need to get a visa to come to the United States, you know, if, say you're an Israeli business person who just wants to come on a business trip to scout an investment or a company that they want to join, you have to get the visa. And right now, as of several months now, since March, the embassies and consulates are all closed, and it's really hard to get any visa. So that probably isn't an option right now. The USCIS processing I talked about, they don't have premium processing, which means all of these cases are taking usually about 2 to 4 months at a minimum to be adjudicated. The USCIS reopenings of their offices for interviews that are related to green cards and some types of visa petitions are going to start just in about a week on June 4th. But otherwise, there are just some things that are slowing it down, and you really don't want to rely on USCIS or the Department of State because they have, when it comes to emergency processing, because they do have some exceptions, but they don't like to give it. They don't like to use them. So essentially, you know, you just got to watch out because most of the processing is either slowed right now or closed.
Thanks, Sam. As we're getting close to the end of the hour, I want to remind our audience, if you have a question, now it's a good time to ask it. And while we are waiting for some questions, some closing statement about really planning for the new normal. Michael and Sam, if you have some last words for us as an advice. It's not a legal advice, but a general advice, please.
Yeah, let me go first just because Michael's going to have a sort of a bigger idea close up. When it comes to immigration, just be careful. You have a lot going on, and I understand whether you're the employee or the employer right now, there's a lot of stress, a lot of people having health issues because of the stress involved. And I know that a lot of the employers, you love your employees. A lot of them have been with you for years and decades. And so you've got to really be careful that you don't overlook some of these issues because it could hurt them. And frankly, it could have them removable from the United States if you don't take care of them. So if you have questions, reach out to your immigration attorney and say, hey, we've got these people on visas. I hadn't thought about it before. What can I do to make sure that we're complying? And you can usually work through it. The good news is the government, although not known for its understanding, they do see that this is a strange situation. So you can usually take some steps even after the fact to try and fix the problems if you have.
Thanks, Sam. Michael?
Thanks. I think that the biggest takeaway that any employer should have is that these are rules that you need to enforce. There are lots of things that employers let employees slide. But right now, the risk, both in terms of actually passing on COVID-19, but also the risk that some employees are going to become upset and afraid to come to work, or that you could be sued for an intentional tort and face much more catastrophic financial losses because of legal liability over small things like ignoring employees who wear their face mask on their chin instead of over their mouth and their nose. Employees who obviously come to work while they are coughing and sneezing. And sure, the employee may say it's allergies, but right now, symptomatic people should be staying at home. And so it's really a matter of making sure that you're enforcing all of the rules, and first and foremost, being a good role model yourself and making sure that you're wearing your mask, you're washing your hands all the time, so you don't come across as a hypocrite when you tell employees they need to do the same.
Oh, you're still muted.
Sorry about that. One question we have from the audience about a topic we plan to talk about, but unfortunately, because of time, we didn't have much time to talk about. It's about working from home, which is very important. It's even crucial. We hear that some employers tell their employees, you know, it's voluntarily, you can come to the office if you want, we keep the offices open. Some employers tell their employees, you have to come to the office. What's your take about work from home, the do and the don't, and responsibilities, and what employees have to do, and how they comply, and how they clock? There are so many questions. I think we need another hour just for that. But maybe in just few words, Michael.
Yeah, so in a few words, right now, all of the legal guidance from the state and from the county is anybody who can telework should be teleworking. And so employers should consider teleworking done by individuals who can do it, that's mandatory. That's the current state of the law. I think the reason why some employers are saying it's technically voluntary, but they're encouraging it, is they're trying to avoid the legal obligation under California law of reimbursing employees for necessary business expenses they incur. And in particular, what they're trying to avoid doing is have to pay somebody for home internet and for their personal cell phone they use while they work from home. I think that is a weak legal position, and employers who are relying on the charade of a voluntary choice to telework are exposing themselves to the risk of class actions. And so employers really need to continue to regard telework as a standard assignment and a required assignment until all of the health orders at the state and county levels are lifted. I would point out that in the Cal-OSHA guidelines that all employers have to adopt, one of them is encouraging telework when possible. So the standard still is, if it's possible, they should be teleworking.
Thank you, Michael. Nira, if you have a specific question about work from home, this is the time to ask it, if you like, or if anybody else has another question. In the meantime, Sam, maybe you have some closing words of advice? Not a legal advice again, but as an advice. And you're on mute.
Sure. I mean, just in general, what I'd say now is it's a good time to plan ahead. A lot of employers, because workforce size is shrinking, and so people you thought you were going to bring over, you're on pause right now on a visa. People you have here on visas, you're not really sure if you're going to go for that green card now or whether you're going to wait on that. But really, you need to sit down right now, have a good overview of all the employees in your workforce that are on visas or on employment authorization documents. Understand their situation and make sure that you plan ahead to file extensions as needed.
Okay, great, thank you. Michael, last word of wisdom?
Take your time and be careful. Everybody's sort of making up what some of these rules are as we go along. The governments are changing them. They teach us in law school, bad facts make bad laws, which means employers that push things too close to the limit and do things that might look to endanger employees are likely to get sued, and they're likely to get over-regulated. So be as careful as you can be, and good luck.
Okay. Thank you so much to Sam and Michael from Squire Patton Boggs joining us today for this session. I can tell you that I already received some comments. People want to ask more questions. People have more, they need more information. I bet from now on we have probably more questions than answers. And I think the regulator and all of us, employees and employers alike, just need to follow their guts, the regulator, and really work together to overcome this situation which none of us is used to. Thank you so much for joining us. This session is being recorded. It will be available in the next few hours on the CICC YouTube channel. If anybody would like to get in touch with the lawyers that were presented here today, the contact information is available. If you have questions to us at the CICC, please don't hesitate to contact us either in our Israeli or our California-based offices. Thank you so much. Stay well, stay healthy, and I hope to see you soon. Have a good one. Bye-bye.
Bye-bye.
Okay.